I mean, all the buttons look the same to me. You know, I mean, but what can you do? All right, hello again. This is Ben Hitchcock Cross talking to you today. Um, Doing the old usual. Had a great 40-minute video with no sound. You know, because I was messing around with stuff. Because that's what I do. So hopefully this is better. We'll see what happens. I changed the de-esser settings while I was messing around, so who knows? Maybe you can hear my S's and maybe you can't. Secret Sibylist from Syracuse suffers simultaneously silly scabs. Huh? All right. So here I am, moving on from my chagrin from the 40 wasted minutes on that. We've got some great Novak stuff. Where I'm saying is we're like this. We're pausing here on Novak before we finish out there. We're going in on bias and Secretary Petchacek and the bind that this Judge Gelhard has here in this other case. What I'm going to do is two parts there. I guess I'm going to telegraph. What I would have done is shown you part one, which would have been and will be yet my motion. I feel like you guys I've explained to you enough in the last video what their position is. I'll read you out my motion again, and then I'll read you out the decision from the judge, and we can go from there. I also have the case log, which is fascinating, and so we can compare and contrast what the judge puts in the order and what's on the, let's say, the case log. So he's got one set of documents that he gives to his superiors and documents for the department, and then he's got another document that he gives to the parties. So that's what we're going to look at. All right. We're almost done with this round of Matt Chasen here. I think we've got 3 or 4 more to go, and then we're going to do Bob Peterson. Remember, he is the super left-wing former hero of mine, founder of Rethinking Schools, public intellectual on the subject of education in public schools, became a member of the school board, and became subsumed in that corporate identity there, and in my opinion, became part and parcel of all the bad decisions that were being made that MPS school board makes, board of directors, educators makes against all the whistleblowers there. I heard, by the way, Hal Leonard said to somebody that the board, this is one of the MPS school board members, that the board thinks that the whistleblowers are just out to harm MPS. And if that could not be a more ignorant statement, I don't know what could be. Because the issue, of course, is why would you think that, first of all? Why would you think that all of them are doing that? Have you really, really taken the time to look at what their concerns are? Have you really taken the time to address them? And knowing what we all know about Matt Chasen and the investigative process, do you really believe that it's anything other than a sham? Really? Well, let's just wait and see what happens with Bob Peterson. And remember, at the end of this one, Chris Reardon, our friend, rage quits and ends the deposition. So that'll be something for moving forward. I want to discuss here, we're just going to talk briefly about my day yesterday. What a day. Pretty exciting. I just have a few minutes, so I'm filling time before horse is going on. Yeah, just filling time. So let's say I've got this case that has been ongoing for some time between a member of a school board and the school board itself. Basically, that they have violated our sunshine laws, or what we call our public records and our open meetings law. This is just focuses on open meetings law. And at issue there was, and this is an attorney that I deal with time and time again, it's called a summary judgment. So we did some discovery. We went back and forth on there, and they said, given all the evidence that's already out there, we should win. And we said, given all the evidence that's out there, we should win. All right? Pretty good situation to be in, pretty tense. So normally as a plaintiff, that's where I'm almost always at working towards, is getting past summary judgment. We've talked about that quite a few times. And remember, the standard here is that there are no material issues in dispute, okay? So that means a material issue, whatever the fact is, there's going to be elements. Whatever the claim is, there's going to be elements here, okay? So to prove a violation, you've got to show that there was a meeting. You've got to show that it was improperly noticed. You've got it like that, okay? Go down the elements. One of the elements is, was there a discussion, okay? And does a discussion, as a matter of law, what does a discussion mean? And was there a discussion? So what comes down is, it's a question of fact, really. And it was really quite astonishing, where their side said there was a discussion, and our guy said, well, one person said something, and then another person said something, and it was unclear, really, whether or not that was a discussion. What does discussion mean? We'll leave that off, but again, the fact really was whether or not there's a bunch of back and forth, okay? So, that was that was some of the things that were at stake. And what was fascinating there about that whole opportunity, or that whole, let's say, how can I frame this? What is most fascinating about working from this angle here of competing summary judgments is you think that somebody's going to win, okay? And that one way or the other, basically, the judge is going to decide who the winner is, okay? I think we also kind of in our minds think that at the circuit court level, there might be a less exacting standard of, if it's close, that there's no disagreement, we're just going to get this thing the heck out of here, okay? Then less so than at federal court. That might be a bias, okay? Every situation is different. We're going to talk about this situation here. So, one other item of note is, first time this has ever happened to me, the client hired a specialist to assist me to work on this case. So I was standing up there and arguing on behalf of my client, but also with the assistance and also the words of another person. Very unique in my situation. Normally I just get up there and talk and we're ready to go. So the other thing that's fascinating here is it's scheduled for oral argument / decision, okay? And who the hell knows what that means? Basically, everybody assumed that there was going to be an oral argument, and possibly the judge would give an outline of what he was thinking, but there wouldn't be an actual decision until weeks or months or who knows what, okay? There might be some back and forth, some questions that need to be answered. Usually, a lot of times, that's what this exercise is about, is having the opportunity to answer questions to the judge or panel of judges, okay, at this point. So that's what I'm in. I'm kind of the way that you practice for that is you read what you wrote, you read what they wrote, you reread all the case law, you try to think of what questions might be outstanding. I went with the other attorney, and he was asking me the hardball questions, and then I had realized what homework I had to go do, went back and worked on those answers, and went back and forth like that. Okay? And that is pretty standard. Another thing that people will do is write out sort of a cheat sheet of questions and answers. I find, though, the drafting of those sheets to be useful. But I find in the moment that finding a particular text or something is almost entirely impossible. But I do feel a lot more comfortable and like to have at my fingertips the case law if needed. So I can say, Judge, that case is such and such versus so-and-so, and that's Wisconsin's second, whatever, the citation. So that is handy. Knowing just the case names and being able to describe them and get down to that's really impressive. But having the case law handy is also helpful. So sometimes I have a cheat sheet for that, or, they say this, we say this kind of thing. But in the heart of the moment, pretty difficult to wrap up. So we walk into the courtroom, and from my impression, the judge is in a bad mood, okay? And this might be him at the best mood ever. I don't know, don't want to put anything disparaging, but my whole point is I'm concerned because I don't have very much experience with this judge, and this is a circuit court across the street. So this is a real judge that could put you in real jail, among other things. Not a federal judge. We call it a circuit court judge around here. It's the first level, the trial court, okay? So most of what they do is bankruptcy, not bankruptcy, debts, like eviction. I don't want to say that. Evictions are more small claims, but such and such company versus such and such for a debt, and then criminal stuff. That's in terms of volume. That's the large amount of what they do. Well, so they do very few open meetings, law stuff, and he seemed to really get into it, which is great. Because what I think we want from a judge is a judge who makes you feel like you've been heard because he listens to you, and his decisions indicate that he knows what's going on, and that he knows the law, or she knows the law. Those are the key things there. And then whatever let the chips fall where they may. But if you feel like you've been heard, and that fairly, and that the judge is applying the law to what he heard, then you feel like that judge, she's giving you a fair answer. And I always say that afterwards, both for compare and contrast purposes, talking about wouldn't it be great if the ERD judges were more like this, or why is it that there's such a standard here, or both people can be called judges when one person really gives you due process and the other one doesn't. Those comparisons are invited. That's what happens. So they're governmental entities, and we're the ones impacted by it, so we're going to be wondering. Okay. So judge has a few other matters to wrap up. He's on the Zoom call. He's got just absolutely no time for anybody, which is, we're a little nervous, not really what we want. So he opens up and basically says, I pretty much already made my decision, but if you've got anything that you think will help me, let me know. And we're like, okay. And he says, well, sometimes people drive a long way down here, and I don't want them to say nothing. And, other times people feel like they want to provide some service for their clients, so they feel like they have to talk. And at a situation like that, I'm going to find the need to make a joke. But boy, am I sitting there on my hands, because I don't want to piss off the judge or seem frivolous in a situation where seriousness is the order. So the opposing counsel has gotten me about every time with this one, and I guess people just think I want to talk because I took the bait, and even though I really wanted to go second, it was their motion because there was cross motions, whatever, I was invited to talk. So I rhetoricized. I did my thing. It's sort of a combination of going over the claims and then talking about America. And I could talk about representative government in America and democracy all day long. So that was something, not much. I don't think I spoke for more than 15 minutes, which is rather brief for me. And I also think that when I said that I was done, not everybody was like high-fiving each other, and I hadn't actually been cut off by the judge and said, thank you, that'll be all, Mr. Hitchcock Cross. So that was absolutely something to keep in mind. So, especially even with that introduction, if you don't have to say anything if you don't want to, but you may want to impress your client, I don't know. So, but as I said, what I did was rhetorize, and I rhetorirized. So awesome. I look back, and the opposing counsel, there's two people there. One who's been in front of the Supreme Court on this issue and others dozens of times, just a heavy hitter all around, like one of the, if you're going to name a top 3 school board attorneys in the state of Wisconsin, you're probably going to reference to her. If she hears me say this, I'll never live it down, but whatever. I think it's all true. And especially on public record stuff. She's really good at what she does. She has a junior, like they often do. The junior was there, and he was the one who spoke. I think it was one of his first times, and it was very brief. The judge immediately stands up, leaves the room, and at that point I couldn't resist myself, and I did turn to the opposing counsel, the junior, and I said, I assume this means that I do not get a chance to rebut. At which case, the judge came back with the coffee mug and some papers and proceeded to read out his decision. I did get feedback while I was talking because he nodded. Okay, so I felt like And which was really funny because I wrote over to the specialist next to me. I think we got him on something, but the guy kept saying what because my handwriting is so illegible I couldn't read it. So whatever. Okay. So just to wrap this all up here, there's one reason I always say that I'm not a politician is because I couldn't do election night. Well, sitting there and listening to a decision, especially when they go over the formalities and everything, is excruciating to me and not my favorite. So we go through here, and the judge says that we lose our motion to for summary judgment, but then he also says they lose their motion for summary judgment. And it doesn't really dawn on me what that means, a trial. Because it's just the whole, again, trying to take in the oral information and take the notes and getting down, like, I'm not even at that level in my brain. I'm also in a performative mode here because I have to take in information, good or bad. I have to look professional, and that's not that easy to do. So, okay, we lost, but they lost. Okay, what does that mean? Then the next one, they lose, but we win, and their argument is deemed to be nonsense. Shocking. The next one, we lose, and they lose. Because there's not enough, which when I'm in on both cases where everybody loses, that's because there isn't, there's a material issue of fact in dispute. We say this, they say that. So now, how do you solve that? You have a trial and let the judge decide what happened. And then on 4 and 5, we had some issue where basically the claims needed to be dismissed. And there's some technicality, and nobody really disputes that. Everybody also knew that we were immediately going to take the claim and refile it or amend it, or that we didn't lose those claims and that they might as well be decided. The judge straight up told the other side, and I'm almost done here, that they didn't, they were going to tell them that they thought that there was material issues for a fact to be disputed, meaning that we would probably have a trial. That is basically a really big telegraph. Just one second here. A very big telegraph to me that and to them that there's going to be a trial on that issue. So that's kind of amazing that the judge is saying, hey, they're going to refile and these things are going to be very likely be a trial here. So you guys need to figure out what you want to do. And the way he's talking, it's not totally clear and I can't tell. And I'm like, Judge, are we going to have a conference today or are we going to have it in the future? So he says in the future, we schedule that out. Okay, fine. I get up, I talk to the Brahmin attorney on the other side. And she immediately tells me, and what's interesting about this is I can feel the judge coming from his podium or back through where I am. And I know they've got two different ways, and it's pretty unusual for them to come past me, but it happened. So I can feel his presence behind me, and I'm a little bit blocking the area. Just because I was blocking the area before I felt him, and I engaged in this conversation. That's the dynamic here. Okay. So I asked the opposing counsel, shouldn't we talk? And she says, this case, there's no way it's going to settle. Paraphrasing. Okay? Which, that's the key part about this whole lesson here is, my understanding in general is you have an absolute right, by the way, to not settle and to have your case heard all the way. But if you refuse to do that, you look like a jackass, and will give the impression to the judge that you're wasting your time. Okay, I'm not saying that this opposing attorney looked like a jackass or that she was wasting time. I'm saying that is what I understood the conventional wisdom to be. So that's why I tell her, hey, you're right, but hey, I wouldn't say that out loud. I would want to negotiate in good faith. Or words to that effect. And I try to say, we also have other issues we need to talk about. I get cut off, and she basically says, no way any of this is going anywhere. We're not settling. yada yada. And I'm like, because I know the judge is behind me and he must be watching because he hasn't moved. He's sitting there. I'm like, but I totally get that, but I don't feel like I'm being heard. That line, by the way, has worked several times for me in the, lately, and I do recommend it. It does seem to have the power to arrest people and encourage them to listen what you have to say. So when I do get my chance, I try to point out that although we should probably talk about settlement, even if just for appearance's sake, we also need to talk about scheduling. If we were going to have a trial, when that would be, and things like that, given our busy schedules and things like that. So there might be a 1-2 track, but even if the answer was 100% no, that we did talk about settlement, we were still going to have issues to talk about. She, I think, agreed, as I recall, and we agreed to, after the holidays, figure out a time to meet. So that there is my little adventure story there. Field trip of Hitchcock Cross field trip there. So in case something else happens, I'm sure we will meet again before the holidays. But if not, happy to you all. And I hope, whether it's a burden or a blessing to you, that you get everything you want out of it. And if not, I hope you take some positive steps to make that happen. All right. Stick with us. We'll keep you informed.